Dan, let's start with the, many people in the room are going to know about this story, the Nadeem Zaharwali story. But for those in the room and those online that are not familiar with this story, can you just give us a sum up of how you got into this situation and what happened?
So I was a tax lawyer for many years. Then I had a rather cliched reassessment of priorities during the pandemic, and I retired. But I loved being a lawyer so much, I thought I needed to keep doing it. So I set up Tax Policy Associates, which I thought would write nerdy policy analysis read by 200 people. But they're right 200 people, so that's fine. Then someone came to me with a story, a journalist came to me with a story, that Jeremy Hunt had avoided tax when he sold his education business. And I looked at it, and it was really clear he hadn't. He paid the tax, so journalist went away. Someone else came with a story about Rishi Sunak avoiding tax and working for a hedge fund in New York. Total bollocks. Didn't stop Channel 4 running a half-hour piece on it. But anyway. Then, for a couple of different reasons, my attention turned to Zahawi. Actually, the first was obvious. There was an amazing story in The Independent that Nadeem Zahawi, who was in the Tory leadership race and was then Chancellor of the Exchequer, had been investigated by the NCA and HMRC, which is extraordinary. So I thought, well, maybe I can work out what HMRC were looking at. So I did what tax lawyers do a lot of the time. You look at someone's company, in his case, the polling company YouGov, and you see if there's anything odd going on there, and there was something odd going on, something really strange. And it was pretty clear that we could see that he'd made a very naive attempt to avoid tax. Man in the pub level tax avoidance, it's described there. And we could actually calculate how much tax he'd failed to pay. Tried to avoid, failed to avoid, just failed to pay. And it was, I think it was about 3.7 million quid. So we published this. And it made a little bit of a stir, but not much. And Zahawi gave an explanation, or his people briefed an explanation. And the explanation seemed to be bollocks. And I wrote that either we'd misunderstood what had gone on, possible, or his memory was at fault, or he was lying. And then after I did that the next day, his people started briefing a different contradictory explanation. So I said, well, he's lying. And anyone who's spent 5 minutes talking to a libel lawyer will realise that was probably inevitably going to get a response. We did get a response. The response was from Zahawi's lawyers, Osborne Clark. And there were a couple of interesting things about the response. One was that they didn't seem to understand what was going on, and it was very muddled. The other was that the response said that we weren't to publish their email or tell anyone about even its existence. And it would be a serious matter if I did. And I was amazed at that. But I discovered that was not an uncommon gambit for libel lawyers. Now, I'm not an expert in the law of confidentiality or privilege, but I suspect, like many of you, I know enough to get by, and it seemed to be nonsense. I spoke to people who were experts in the law of confidentiality and privilege, and they were very confident it was nonsense. But still, Zahawi was reputed to be worth £100 million. Given the plaintiff-friendly nature of our legal system for the very rich, as we heard a few minutes ago, running a case you're even very confident on against someone worth £100 million is not a very appetising thought. So what could I do? Could I tell anyone about this letter? But we continued to work on the tax, and I was speaking to dozens of tax people around the country, and the more people I spoke to, the more confident I was that his tax was really wrong. But that changes everything, because once I was confident that he had, in fact, avoided the tax and he had actually lied, then it becomes clear he would never bring any legal action against me. The prospect of having to disclose his documents, the prospect of being cross-examined, was just wildly implausible. So at that point, my nervousness about the confidentiality point disappeared, and we published. We published, and I also made a bit of a fuss about this attempt to silence me, because it absolutely was an attempt to silence me. You don't write, you are not entitled to publish this letter or even refer to it, and if you do, it will be a serious matter. That's a threat. If a lawyer says something's a serious matter, that's not a neutral description of the state of the law. That's a threat. So I wrote to the SRA, initially not about the specific lawyer, but about the principle of the point. And the SRA reacted with remarkable speed and came out with a warning notice that was not sarcasm. Now, I think if you tried to design a perfectly efficient legal regulator, they wouldn't be much faster than the SRA was with that. They reacted within 6 weeks, 2 months, something like that. I think that was fast. And the warning notice said, don't do this, which was great. And I then made I don't know if it was necessary, but I made a complaint against Osborne Clarke for having written that letter. And that went before this listener's disciplinary tribunal at the end of last year. And I think I'm not supposed to say anything that isn't public, but the hearing itself was public. So his defence was that it was perfectly proper. Well, I think he had two defences. One is that it wasn't meant as a threat. I don't know what the meaning was, but never mind. The other was that it was correct. That, let's say, you guys draw a picture of me bald. I am then entitled to send you a libel letter saying it is an outrageous defamation to say that I am bald. I require you to destroy all copies of this. And by the way, you cannot publish or refer to this communication I've just sent you. And on the legal theory of Osborne Clarke, that is binding. Never mind how stupid my defamation assertion is. The existence of the letter is embarrassing to me and therefore confidential, and you can't publish it. Now, I think, as a proposition of law, that is offensively wrong. The idea an English judge would accept that proposition seems extraordinarily far-fetched to me. So I don't know on what basis the SDG ruled, because we don't have the judgment yet. They are officially slower than the SRA. But I do know that they found that it was improper for him to make that threat. So that's an incredibly long answer to your question.
No, it's a very fascinating answer to the question. The SRA came out very well in that answer, by the way, which is very good. Look, this letter arrived in your inbox or however you received it, and I've seen you say in the past that you were someone that were not afraid to take up the legal fight. So they sent it to the wrong person. But of course, many people that receive letters like this, and they are very common, I know they're very common, as you've said, would not be in that position. How would they deal with a letter like this? I mean, do we need more regulatory assistance to stop this happening?
So quite the worst case I'm aware of involves... Is this being webcasted or anything?
Yes.
Yes. Okay, how vague do I need to be? You may all be aware that there is a tort claim for sexual assault against a wealthy individual, which is currently anonymised. I can't remember what 3 initials he has in the anonymisation, but he has 3 initials. Who here is aware of this? Everyone's aware of this? Oh, okay, hardly anyone's aware of that. Wow. So it shows how effective this is. So it's a very serious accusation, and it's anonymised. Now, the other women who say they're assaulted by the same person have made allegations about that on social media, not referring to the allegations that's the subject of the anonymity order, but referring to their own case. Those women have received letters from a solicitor acting for the 3 letter individuals saying that their posts breach the anonymity order and are potentially a criminal offence. And their response has been, understandably, to be extremely scared and to delete their posts. So, yes, we shouldn't assume that these letters are ineffective, even against well-advised people. Newspapers. How often do you see newspapers publish these slaps they receive? Almost never. Because they, too, are worried about the risk of being pursued on marginal points by very rich people. But then when you come to bloggers, when you come to very vulnerable women who've been assaulted by an individual, allegedly assaulted by an individual, then these letters have an amazing amount of power.
So where do you believe the line is? Because, of course, there is a place for lawyers representing clients in the way that you've described to stop people publishing and so forth. There's a place for it. But when does it cross the line into being unethical?
It's a difficult question. The question that's unresolved from the Prigozhin case and a couple of other cases which are live at the moment is, what does a solicitor have to do, if anything, to satisfy himself a factual claim is true before pursuing it in correspondence. Stupid example, the baldness claim again. I instruct Carter Ruck to sue these fine gentlemen for defamation for drawing me bald. Are Carter Ruck able ethically to write a letter saying it is false and defamatory to say that Mr. Needle is bald? Are they able to do that? I mean, that's ridiculous. Surely not. What if I told them actually I've got a rare medical condition and I'm actually wearing a bald cap over real hair and I'm not bald? Are they entitled to write on that basis? How far does it have to go? Where is that line drawn? I mean, I would say as a matter of common sense, it's, there was a scientist, it may have been Feynman, who talked about levels of proof. That if I go to you now and say, I have a mobile phone behind my back, you're just going to believe me. If I say I have a brick behind my back, you'd be a bit surprised, but you'd probably believe me. If I tell you I have a gold bar behind my back, you probably want to see it. And if I tell you I have an atomic bomb behind my back, even if I show it to you, you're just not going to believe it. We all in everyday life, as well as in physics, apply a different standard of evidence by reason of the claim being made. So, similarly, I think, when Prigozhin brought a defamation action on the basis that he was not the leader of the Wagner Group, when he had been sanctioned for being the leader of the Wagner Group, that should have required quite a high level of due diligence by discrete law. I don't know if that's the SRA's view or not. The point appears to be legally untested, but I think we need it to be tested. We need a case like this to be run. The other case, which we're still waiting on an SRA outcome, involves OneCoin. So OneCoin was a supposed cryptocurrency run by a mysterious Bulgarian lady, which sold vast amounts of its coin to people across the world, generally in the developing countries, here a little bit in ethnic minority communities, but not into the mainstream in this country. But they made hundreds of millions from this. Tech analysts realised quite quickly that this was a fraud for a bunch of reasons. Anyone interested? Quick plug, Tax Policy Associates website. We have an analysis of what happened in OneCoin. But it became clear quite quickly it was a fraud. And Carter Ruck were engaged by OneCoin to write to people making these allegations and say, oh no, it's false and defamatory. Our client's business is not fraudulent. But on the information Carter Ruck had and on the information they wrote in their own letter, it should have been clear to anyone with a room temperature IQ that the business was fraudulent. So what happened? I fear in this, as in the Prigozhin case, we won't actually know. The SRA, I fear, will come out and say that nothing improper happened, and we won't have any ability to test that. Well, I'd like to test it. The OneCoin was a fraud. It follows that an attempt to sue anyone in defamation for claiming it was a fraud is also a fraud. Fraud unravels everything. OneCoin's correspondence with Carter Ruck was never privileged. So I intend to file an FOIA at the SRA to get copies of the correspondence between OneCoin and Carter Ruck. Similarly, Prigozhin's defamation claim against Elliot Higgins was a fraud. So I think we should all be entitled to see the correspondence between Prigozhin and discrete law. Now, why do that? One reason is to help us understand where the line in the sand is drawn. The other reason is to create a little bit of an incentive for people not to run fraudulent libel claims. Like today, if I go ahead with my bald libel claim, if they receive a letter from Carter Ruck, rationally, they'll be mad not to assent to it, unless they've got deep pockets or someone backing them. So I've got a pretty powerful incentive to try it on. And even if they tell me to take a hike, I haven't really lost out. Running a fraudulent defamation claim is a one-way bet. Now, the primary responsibility for that being so broken, I'm afraid, lies with Parliament. There is nothing to stop Parliament creating a tort or even a criminal offence specifically for people making false claims in the course of defamation actions. I think they should. But we can push it at the edges by requiring lawyers to at least meet a certain standard of testing their clients' assertions. And maybe, we can put a bit of pressure on people in that scenario by making clear that their correspondence will not be privileged. In the end, this is a game of people trying to sanitize their name. And the more publicity, the more light can be shone on their activities, the less appetizing a prospect that is for them. So I'm going to have a go at that. We'll see how it goes.
It's an interesting prospect. If a barrister or a solicitor wants to write and assert fraud, they do have that test already. They cannot do that without, or not supposed to do it, without actually having sufficient evidence. But what you're saying is we don't have the same thing in relation to defamation. So we're here today to talk about change, to talk about action. What do you think needs to happen? And we shouldn't just focus this on the SRA, because there's other regulators. We have the Bar Council as well. What should happen in relation to regulating this, as you're quite rightly highlighting, important area?
Well, I think there needs to be clear guidance in the first instance and then tested in front of the SDT on that question of how far a lawyer needs to go to satisfy themselves an accusation is false. Second, there needs to be firmer action on attempts to silence unrepresented individuals. It seems an extraordinarily serious thing for a solicitor to do, and yet it's being done on a very large scale. Beyond that, I'm afraid, it becomes outside of the scope of this conference and goes into a question for Parliament, in particular a question around defamation law. You know, defamation law is plaintiff-friendly. That is not the fault of the lawyers. That's the fault of the law. And I don't want to be mean to members of Parliament, but I am frustrated when members of Parliament blame the profession for the law. Yeah, we could easily have a libel law like America, where to be able to sue, you have to show malice. Where it's a public person being defamed, you have to show malice on the part of the person making the statement. Now, libel lawyers are against that, of course. I don't really care, but if you want to end slaps, that's certainly one way to do it. Another way to do that would be make the public interest defence less of a dance that's highly favourable to the rich and powerful, which is what it is at the moment. I'm not sure Parliament intended that, but that's how the courts have interpreted it. Another way would be create some kind of punitive consequence, people making fraudulent defamation claims. Now, the reason this is quite hard, I believe, is very sophisticated and energetic lobbying by the Society for Media Lawyers, who say again and again there is no such thing as a slap or slaps for a tiny problem in the UK. Now, I spent 5 minutes this morning. Hang on, I should pull out my notes because there are far more than I can remember. I spent 5 minutes this morning looking at the slaps, just that I'd emailed people about. Recent slaps. So we have Carter Ruck acting for OneCoin, a fraud. Discreet Law acting for Prigozhin, a fraud. Zahawi trying to stop me talking about his avoiding of tax at the same time as he was settling that tax avoidance with HMRC, a fraud. Shillings acting for Russell Brand, asking Metro newspaper to retract a clearly factual report about a joke Russell Brand had told. A really troubling one, Archerfield Partners acting for Russell Brand to prevent reporting of accusations of sexual assault by Ms. Berkey. And this is concerning because she was unrepresented, but an anti-harassment restraining order was granted, which prevents her talking to anyone about this, even the police. Unrepresented. It went to the Court of Appeal. At the Court of Appeal, the judge, a female Court of Appeal judge, essentially said that Ms. Berkey's route here was to go to the police and that there was no need for her to publish it. The court could not see a public policy to publish it, probably aided by the fact that she was completely unrepresented at the Court of Appeal on a lifetime anti-harassment order. Amazing. Jonathan Code, acting for PPE MedPro. This is Douglas Bowerman's company. It was widely reported that he was behind a company that had supplied useless PPE to the government. He denied it. He got Jonathan Code to threaten the Guardian with defamation. But it was true. And Bowerman later admitted lying. Code was so disgusted that he apologised to the Guardian and called out his own client. I know many lawyers who respond to that saying that was unethical of him, he breached privilege. No. The claim was a fraud. If you instruct a lawyer to lie on your behalf, then privilege falls away. It must do. So Code is, as far as I'm concerned, the only ethical lawyer on this list. Carter Ruck acted for the president of Malaysia's Islamic Party in a bizarre case against Claire Rewcastle-Brown to prevent her reporting about corruption in Malaysia. A completely meritless legal and factual case. Wirecard. The FT reported that the German company Wirecard was a fraud. I don't know which firm acted for Wirecard, but one did. Wrote to the FT threatening defamation. Of course, Wirecard was a fraud. I'm not going to go on because it's too boring for you all, but that's half my list from 5 minutes this morning. SLAPP is a huge problem in the UK. And it's great people come to the UK from all over the world and use our courts and use English law. That's fantastic. But the reason they use libel law is because there is no downside for them. If you are worth hundreds of millions, billions of pounds, the legal fees are inconsequential. And what's the worst that can happen? You give some small change to some lawyers. What's the best that can happen? Your reputation remains unsullied. We can't allow people one-way bets of this kind. And in some of these cases, I think the lawyers could have acted differently, should have acted differently. But in others, you can't really blame the lawyers. You have to blame the law. And that is something that Parliament is responsible for. I've heard from quite a few MPs that the feeling is that SLAPP was solved by the SRA's warning notices, which would be great if it was true, but the Prigozhin result, I think, makes crystal clear that it is not true. If the SRA cannot save us from the Prigozhin case, then the SRA can't save us from SLAPP.
Do you think the other issue as well is that it may well have gone partway towards solving the issue, but for lawyers like you and I that may know about that, that may be a solution. But to those who do not know what the SRA's position is on this, or potentially how to complain about it, it's still an issue, isn't it? I mean, what do you think needs to be done to solve that issue?
I don't know. I think if there had been extremely serious sanctions against discrete law and the individuals involved, then that would have percolated across the profession. I mean, in the end, yeah. I worked in a... Sorry?
No sanctions?
No sanctions at the post office. Yeah, hopefully the answer is there that it's coming. But in the end, there have to be sanctions, and sanctions have to be reasonably fast. But if there are firm, credible sanctions which people see being delivered, then that will change behaviour. So far, that hasn't happened, with the small exception of the don't publish or refer to this letter, which does seem to have changed behaviour a bit. Although there's been an adaptation by some sections of the solicitor's profession. The latest tactic is not claiming confidentiality, but instead claiming copyright. You say, this letter we've sent you is copyrighted, and therefore you can't publish or refer to it. So the answer is, sure, it's copyrighted. And if I print it on a T-shirt and start selling it from market stalls, you can sue me. But the law of copyright doesn't prevent me publishing something in the public interest, and you'd have no damages, even if it did. So, yes, hopefully we'll get a test case on that soon.
I'm sorry, I'm going to be really naughty.
Go on.
I tried to put something on your WhatsApp, but it's too many characters. And can I just simply say, it's not just at the top and very rich people, but we've got local authorities suing people for after their relative has died, for care at home, which could not possibly have been care at home. And the barrister concerned did not even look to see that 6 months of the bills were out of date and that some were after it dead or were in hospital. It's a waste of court time. The solicitor involved, the barrister involved are going to have no sanctions. We are litigants in person. What can we do to get them sanctioned for wasting court time? So they haven't even looked at the basics.
Well, if they're running meritless cases, then that is in principle against the SRA guidelines and the Bar Standard Book.
SRA guidelines. Nothing happens. There is no sanctions. Nothing happens. The thing that my friends still happened to me, they were suing me for fees for my father's care at home. When he was in a private care home, when he was in a coma in Croydon University Hospital, and after he was dead, all the way. Nothing happened.
Has it been referred to the SRA?
Yes.
And
Can I just add that our standards board here, in the handbook, it says part 5 of this handbook sets out the regulations which bind the BSB when it considers alleged breaches of the code. And then underneath that it says A4, Rule 5. The Bar Standards Board shall have the power to waive or modify any requirement of this handbook in such circumstances and to such extent as the Bar Standards Board may think fit, either conditionally or unconditionally. So they say, we, the Bar Standards Board, are bound by these rules, and in the small print they say, we can ignore any of these rules if we so desire.
Dan, do you think this is a good example of where there needs to be some harmony between the likes of the SRA, the Bar Standards Boards? We need to have a common rule for this across the board so there's no discrepancies and no issues like this.
I mean, that is a specific area that I don't know anything about, but in a completely different world, I've been looking at a rather odd example of a dichotomy between the two. So, let's say I set up in business selling a tax avoidance scheme which involves throwing your money between 6 different companies in 6 different countries, and you end up magically paying no income tax. For about the last 30 years, a scheme like that has zero prospect of success in the courts. Some people continue to sell it, and so in the early 2000s, the accounting professions came up with a set of conduct rules governing tax advice. And one of those was that you mustn't construct schemes which go against the clear intent of Parliament, because you'll lose, you'll let your clients down. The SRA bound solicitors to that code. Chartered accountants are bound to it, chartered tax advisors are bound to it. Barristers are not. So when we've looked and we've investigated many quite egregious tax avoidance schemes, which are a matter of consumer protection as well as ripping off HMRC, almost never are those schemes pushed by chartered accountants or solicitors. They're being pushed by barristers. The KCs and some juniors. It's a very small number, but they have a brilliant competitive advantage in being able to do something that others cannot do. But it's a deeply wrong competitive advantage. To the BSB's defence, the adoption of these of the tax conduct rules preceded the creation of the Bar Standards Board. So it may be the Bar Standards Board has never looked at this question, but it's very odd that a different standard applies to the bar than it does to solicitors.
Dan, thank you very much. We're out of time, unfortunately.